I am Saul Berkovich. We welcome you to this presentation. I am CLA's Chief Governmental Affairs Officer. We have, backed by popular demand, we did this program, similar program 4 years ago on the 2020 ballot. We got the same speakers. We have Mary Beth Moylan, Associate Professor of Law at McGeorge. She's admitted to practice law in California in 1995. She worked as a law clerk for Judge Carlton in the Eastern District, then practiced election law and general civil litigation. Since 2003, she has supervised publication of the California Initiative Review, an online journal providing objective and neutral analysis of each statewide ballot proposition. She teaches a California Initiative seminar at McGeorge where her students study and analyze the measures. And this year, her students will be presenting their analysis on October 22 at the California Initiative Forum in person at McGeorge and also live streamed. Second speaker is Ned Wigglesworth. Ned is CEO of Spectrum Campaigns. Ned specializes in ballot measure campaigns and issue advocacy. Primary focus on complex issue areas such as healthcare, energy, state finance, and governance. He's worked with stakeholders across the political spectrum on numerous initiative campaigns since entering public affairs. Ned has a JD from University of Michigan, previously worked as a litigation attorney, and has been hired by corporate general counsels to provide strategic and communication support for litigation. So our plan today is we've got an hour and a half. We have a lot of stuff to cover. We have 10 propositions that are on the ballot, and then we're going to be discussing some that qualified and are not on the ballot for various reasons. If you have any questions, you should see a little Q&A box, and you type your questions into the box, and we'll try and answer all the questions. Proposition by proposition, we might have some time at the end if they're overarching questions, but with that, we can get started. So we're going roughly in order, except in the beginning we grouped a few together. So the first grouping is bond measures and bond changes, starting with Proposition 2, and that's Ned's.
Thanks, Saul. Hi, everyone. We're going to talk about Prop 2, Prop 4, and then a little bit about Prop 5. Prop 2 is a school bond. Prop 4 is the climate bond, and Prop 5 is a rule change related to the passage of local bonds for housing and infrastructure. Prop 2 is pretty straightforward for as school bonds go, right? We voted on these every 4 to 6 years. California voters last voted on a school bond in, I believe, the March primary of 2020 and voted it down. It was they should have gone on the general election, not in the primary. This is very similar to prior education bonds with one exception. It does not include money for UCs. It's just for public schools and charter schools and community colleges. It's $10 billion in bonds, which translates into something north of $20 billion in current financing costs, or maybe just a little shy of $20 billion in financing costs all in. It's largely being framed as to repair, upgrade, and modernize California classrooms, both for public schools and community colleges. This is this measure is landing at a time that California voters, and we're going to talk about this in a couple of contexts of a couple other measures, at a time that California voters are just have incredible antipathy towards higher taxes, and they have incredible concern about the rising cost of living. This is particularly so for, in California, it used to be that the older cohort, folks over 55, were the most conservative. They were whiter, they were older, they were homeowning or property owning. They tended to be more Republican. They tended to be more fiscally conservative. The new fiscal conservative cohort in California politics is 35 to 55. It's people who have kids, who are sort of a parent, have kids in the home or paying for kids' college. Those are the folks that are who are most impacted by rising costs of living, by higher taxes, and those are the folks that feel the most pinched. So this particular measure sort of lands in that issue environment, and is going to be impacted by a couple of other fiscal measures on the ballot as well. This measure is polling decently. It's polling at something like 54, 44 in the recent PPIC, and another poll had it at 54, maybe a little bit lower on the no side. It's probably going to pass. Excuse me. With the caveat that some of these attitudinal headwinds in which people have concerns about the rising cost of living and also about whether their money, their tax dollars are actually being spent effectively, whether this is going to be a good idea. In terms of the campaign dynamics, it's being backed by developers. And that may seem a little bit weird, but it's backed by developers because the more that we pay for school construction via bonds, the less they have to pay for that at the development stage. It's being backed by building trades and it's being backed by the education community. They're probably going to come up with, I think they've got a budget of something like $10 million. I'm not sure they're going to get there on the yes side. The no side is basically Howard Jarvis Taxpayers Association, which has concerns about how well the money's going to be, whether California can afford increased debt load, and whether the money is going to be spent well. This is likely going to pass, but not unreservedly so.
Okay, we got a couple questions. One housekeeping that I forgot to say at the beginning. Yeah, everyone who registered will get the handout. The handout will be a PDF of what you're seeing now. So everything we're showing now will be available to everybody who registered. There are a couple questions. Some look more like comments than questions. I'm just going to hit a couple of these real quick. Where does funding for state colleges come from if not included in the proposition?
There's the state universities have their own budget item in the California state budget.
And I think the other one's a larger question, so we may need to come back to that if we have time, which is why we constantly have more bonds for public schools when we have huge infrastructure and homeless problem. I think that could be its own program, so we could put a pin in that one. And
the one thing I would flag, Saul, not being responsive to that question, but just sort of another thing for the issue environment, is that this is $10 billion in school bonds at the state level, but a number of voters are also going to see school bonds at the local level. There's a $9 billion school bond in Los Angeles. There's a roughly $1 billion school bond, I think, at Sacramento. There's another handful of school bonds sort of sprinkled around the state on top of this one. And you do get from some voters who ask that question, like, why are we spending more and more money on schools, particularly given that proliferation?
Okay. Do charter schools include religious schools? My understanding is charter schools are public as opposed to.
This is public charter schools. This is not for private schools.
Okay. Thank you. So then 4 is the next bond.
Yep. So 4 is benefits from Californians, widespread support, widespread belief that we need to do more on wildfire, that we need to do prevention, that we need to do more on drinking water, and that we need to do more on climate generally. It's a climate bond when really climate bond is really just a loose umbrella term in this instance to package a bunch of sort of interest groups wish list for dollars. In this instance, it goes to safe drinking water and water resilience. Some goes to wildfire prevention. Some goes to the protection of natural lands. Some goes to coastal protection, and some for ag. This is doing better politically than the school bond, I think in part because it's interest groups have not gone to the well on a climate bonds as much as they have on school bonds. And it's also climate bonds. Voters have less problems with climate spending than they do with education spending. There's a lot of voters who are dissatisfied with the public education system for various reasons, whether it's on the left or whether it's on the right. Climate bond sort of gets to avoid some of those concerns. And so the climate bond currently at last PPIC was testing at something like 68.31. And in the most recent USC poll that they released, something like 66.24. They also are going to have something like $10 million or so on the yes campaign. There's going to be very little spending on the no side. This is not guaranteed to win, but very likely is going to win. You're not going to see a ton of ads on this. It's going to be fairly quiet, all things considered.
Okay. Will recording be available for later listening? Yes, it will be, at least until the election. This program, important program, but has a relatively short shelf life. So 5, got a couple technical things here before we get to the substance.
So Prop 5,
go ahead. Go ahead.
Sorry, Saul. Yeah. Oh, so what Prop 5 does is Prop 5 is a follow-on to Prop 39 in the year 2000. with Prop 39 lowered the threshold for local voters to approve school bonds that met certain accountability and oversight requirements. Prop 5 extends that basically. So currently, right, the currently threshold for voters to approve local bonds other than school bonds is 2/3. Prop 5 lowers the threshold for voters to approve bonds for affordable housing and infrastructure to 55%. Affordable housing is not just affordable housing as sort of some folks think about it in terms of publicly subsidized housing. It lowers the threshold to approve bonds for not just that kind of housing, but also to help build just generically more affordable housing, including folks that like with eligibility up to 150% of the average area median income. It also includes a number of accountability and oversight requirements for those bonds to be able to be passed with a 55% vote. To pay for these bonds, it also lowers the threshold. It also means that with a 55% vote, local jurisdictions can raise their property taxes over and above the 1% cap that existed in Prop 13 to pay off the bonds that are passed under Prop 5. And so in doing so, what you'll hear from opponents of Prop 5, like Howard Jarvis Taxpayer Association and other folks that are sort of adherents to Prop 13, is that Prop 5 weakens Prop 13 in doing so. There are on the yes side here is so this got on the ballot with a 2/3 vote of each house of the legislature. On the yes side, there is a broad coalition of the Democratic Party, public employee unions, private employee unions, and sort of like the building trades and folks like that, of housing advocates, of community groups, et cetera. On the no side, it's going to be tax advocates, business community, California Chamber of Commerce, California Business Roundtable, the California Taxpayers Association, Howard Jarvis. This is an interesting measure in that it doesn't actually build new housing all by itself, nor does it build more infrastructure by itself. An infrastructure definition can be everything from fire stations to hospitals to roads to water systems to libraries to parks. Incredibly broad definition of infrastructure. It doesn't actually build any of that. It just makes it easier. It lowers the threshold for local jurisdictions, cities, counties, special districts to pass bonds that meet these accountability and oversight requirements. So on the one hand, it doesn't actually build any of these things. At the same time, it doesn't raise taxes. What it does do is it makes it easier for local jurisdictions to pass bonds to do these things, and then also makes it easier for them to increase property taxes above the Prop 13 increment in order to pay off those bonds. It's not quite a coin flip. This one is going to be a little bit more contested. The polling on this is in the recent PPIC was 49 yes, 50 no. In a recent USC, it was 43 yes, 35 no. It's a more complicated measure. It's not going to see a huge campaign on either side, either on the yes side or the no side. So it's going to be, when you see complicated issues without a whole lot of spend, there tends to be a great deal of uncertainty. And particularly on an issue like this, where on the one hand, people want more affordable housing and they want better roads and they want better water. And on the other hand, they have the strong set of fiscal concerns, right? And sort of cost sensitivities that we talked about in the context of Prop 2. So this really is it's not a clean ideological fight. It's one which even a lot of voters in the middle are going to feel pulled in both directions. And absent the big dollar campaigns that we see on some of the other issues, it's going to be very interesting to see how voters sort through those, right? Those conflicting cross currents even within themselves, and ultimately how they vote on this. So this one's going to have some question marks. Ultimately, the ballot label here, the fiscal impact says borrowing would be repaid with higher property taxes. That language is really brutal right now in this opinion climate. Would not be surprised if this measure goes down because of that language. One other interesting element here, and I think Saul highlighted it here, and this sort of goes to the importance of the ballot label, which is the language that appears on voters' actual ballots that they use to vote on propositions. Under California law, you are able to contest the ballot label that you receive from either proponents or opponents are able to contest the ballot label that the Attorney General provides with the assistance of the LAO, which handles the fiscal impact. On Prop 5, Howard Jarvis Taxpayers Association sued the Attorney General in Sacramento Superior Court for failing to note that Prop 5 would lower the threshold from 2/3 to 55%, and just saying instead the language that you see here on your screen. The court agreed with Howard Jarvis and actually ordered the inclusion of the language in the yellow here rather than current 2/3 approval requirement. However, the Attorney General appealed that ruling successfully because the standard for successfully getting the ballot label language change is incredibly high. And so with that, I'll throw it over to Mary Beth for a sec to talk about that standard and why that matters.
Yeah, thanks, Ned. I do want to just talk for a very brief minute about that, because I think it is important to understand, and people assume that because the Attorney General is drafting these ballot titles and summaries, that it's a very political exercise. And so I always like to mention as an initial matter that there's a whole unit of the Attorney General's office that is staffed with civil servants. It's not like the Attorney General, him or herself, is, sitting under candlelight drafting intentionally politicized ballot titles and summaries. I mean, occasionally they become political, but for the most part, you have people who have been drafting and are doing it in a way that is objective and neutral, and are doing it in a way to try to best represent what the initiative does. It can be very difficult to do with only so many words. It can be very difficult to do when you have complex matters like this one is, to try to actually concisely articulate what is at the core of the measure. And because it's the only thing people see when they're voting, it really is critical that we have an accurate description of what the core changes will be. So I do want to say that first. Then when you get to the question of challenging a ballot title and summary, it doesn't have to be that it is the best representation. The Attorney General has discretion and some leeway. It's a ministerial duty of the Attorney General's office to accurately summarize the measure for the ballot. But within that, the courts are not going to wordsmith the choices that are made by the elected official's office doing its ministerial duties. And so it is a very high standard to overturn the ballot title. It has to be that it is not accurate or that it is in some way misleading. And I think that the Third District Court of Appeal, which is the appellate court that heard this case, determined that this was accurate. It's not misleading. It may not be as inclusive as some people would like. Somebody might have written it differently, but it's accurate in the changes that it aims to make to the law. So one other thing I wanted to mention about this one that I think is important to note is that state bond measures can be approved with just a 50% threshold, right? So when we're talking about Props 2 and Prop 4, we don't need any supermajority to pass those. We need 50% plus one. And the fact is that the Constitution, really from the 1870s, I think, has had this 2/3 requirement for local bonds. And so this is an attempt to change the California Constitution to reduce the supermajority that's needed, but not to eliminate it down to what state bonds have, which is just the 50%.
Okay.
Thanks, Mary Beth. So just two quick things. One, the reason why people contest ballot label language, why campaigns do, is because it's critical it's the single most important data point that voters use to determine how they're going to vote on something, in part because it's the actual language that they vote on. And so campaigns spent a great deal of effort, both at the level of, even at the drafting of a measure, but certainly when it comes to talking to the Attorney General, civil servants, and to talking to the legislative analysts about what goes into this language, because it's so important. And that's why you see parties sometimes litigate, because it's so important, even if the standard to sort of change language is incredibly difficult. The second thing I wanted to point out, and I'm just full disclosure here, I'm working on the yes side of Prop 5. But the second thing I wanted to point out, which kind of is on the other side, is that unlike Prop 39, which is really confined to education districts, right, to school districts and to community college districts, the Prop 5 would apply to cities, would apply to counties, and would apply to special districts. So a big concern of the taxpayer community and of the business community is that because you have these multiple jurisdictions, you could have a single property owner, whether it's a homeowner or owner of commercial property, essentially have to pay higher property taxes to pay off these bonds for a number of different districts at the same time. You could be in a city, you could be in a county, and you could be at the intersection of 3 or 4 different special districts for fire, for water, for hospital, for sewage, for whatever, in which you're essentially having to pay the freight for all of these. And so unlike the school bond, you're actually have increased additional exposure on the tax side. To answer the question I think I saw in the Q&A, the taxes only exist as long as you're paying off the bond. So whatever the tax increment that goes up disappears when the bonds are paid off.
Okay. One asking, somebody I think is raising their hand, but that's not, if you have a question, we'll only see it in the Q&A. That's just how this is set up. Real quick, back to Prop 4, I missed this. What is the 300 million for agriculture to be spent on specifically, or does it not get to that level of detail on Prop 4?
Yeah, I'm not sure, so.
Okay. All right. Now we're moving on to the next sequence, which are a couple civil rights-based ballot measures. First is Prop 33, and Mary Beth, take it away.
Okay, so Proposition 3 is a legislative constitutional amendment that will remove the language that was put into the California Constitution by Proposition 8 in 2008. That language said that marriage is between one man and one woman, and this initiative would remove that language and substitute it with language that says that there is a fundamental right to marry, and further, it would articulate where that right comes from. So the language of the Constitution would indicate that the right to marry stems from rights to enjoy life and liberty and to pursue and obtain safety, happiness, and privacy that are guaranteed by Section 1 of the California Constitution, and also that the right to marry emerges from California's due process and equal protection rights, which are guaranteed in Section 7. So why are we doing this? Proposition 3 won't actually change anything in California currently in terms of who has the right to marry. Whether or not this passes, the language that's currently in the Constitution that defines marriage as between a man and a woman is unenforceable through court decisions that have said that that language violated the Equal Protection Clause of the United States Constitution. But the concern is that the language of our Constitution should be updated. And the other concern is that since the Dobbs versus Jackson Women's Health decision in a couple of years ago now, since that decision, there is some concern about the rollback of the judicially enforced due process rights. Justice Thomas, in particular, wrote a concurring opinion in the Dobbs case that indicated that the doctrine of substantive due process is, quote, particularly dangerous, and that many of the court's substantive due process precedents might be at risk. So California and other states have taken steps to enshrine some of these other fundamental rights in the Constitution. So we had We had 2 years ago a measure to make sure that it was clear that reproductive freedoms were contemplated by the California Constitution and that there would be a separate California right to reproductive freedom. This is an attempt to enshrine the right to same-sex and interracial marriage, to ensure that just because the U.S. Supreme Court might change the bar in terms of what is protected as a fundamental right, California's Constitution will protect marriage. So that's Proposition 3, and that's why it's happening now. Colorado and Hawaii also have similar ballot measures that are happening on this same topic.
And there's 2 questions. Before I get to those, there's a question. We're trying to keep up as much as we can. There's a question on the bond measures that raise the issue of rent and rent control. We're going to spend a fair amount of time later on rent control. So I'm not ignoring anybody. I'm just trying to sort of triage here. So on Prop 3, would it allow multiple people to join together in one marriage, which is I'm not sure this has an impact on that one way or the other. But
well, I think the answer is that there are already existing laws that limit that, and this doesn't touch on that. I think that we have addressed polygamy and other, and people also bring up, well, would you be then able to marry someone who's a minor, or, any of those laws are still in place and would not be impacted by this change.
Okay, and then there's would the U.S. Supreme Court's how would this interact with U.S. Supreme Court current position that gay marriage isn't protected under similar provisions of the U.S. Constitution?
Well, so currently gay marriage is protected by the U.S. Constitution. The concern is that the Supreme Court might change its rulings, and this would be a way for California to say, under the California Constitution, not the U.S. Constitution, there are protections. And state constitutions are allowed to be more protective of rights than the U.S. Constitution. The U.S. Constitution is a floor, not a ceiling, on the protection of rights. And so this change would be intended to allow for a higher standard of right protection in California than the U.S. Constitution.
Okay. Opponents argue that by making marriage a, quote, fundamental right, this amendment opens the door to underage marriages, removing age requirements.
Yeah, again, my answer to that, I think I already said, is I don't think that it removes any other requirements of marriage that can be done statutorily and are done statutorily in California. And then the question would be, do those limitations meet a standard of scrutiny that would be required? So even though you may have a fundamental right to marry, that doesn't say it has to be an unrestricted right to marry. It says that the state has to have compelling reasons. And I certainly think for age requirements and other types of restrictions, there is a compelling state interest to ensure safety and the public's safety.
Okay. Okay. Is there a case before Supreme Court right now regarding marriage? Not that I'm aware of.
There is not, but this is just trying to be proactive, I do believe.
And I see the question about the future. I hopefully we covered that. If not, remind us at the end. So
I would just say,
go ahead. Sorry, Nan.
I would just say, Saul, that like the Prop 3 is going to pass. I think the polling was 68-31 in the recent PPIC. There's not going to be a meaningful campaign on this. The supporters have not been able to raise much money. I think maybe they get a 3 to 5 million, if that. Opposition, there's a few family or religious center groups who are opposing Prop 3. They don't appear to have a lot of money or be on track to raise much money. And so this is probably going to pass without much public discussion at all.
Okay. Prop 6. So just to be clear what's happening here. So this is the official title and summary out of the ballot pamphlet. There have been a couple questions about what is this really doing, and isn't this really unlawful already? So on this particular one, we just, the note at the bottom quotes what the statutory amendment would be on this first piece. The statutory amendment, I'm sorry, constitutional amendment.
Constitutional amendment.
Constitutional amendment on the first piece. On the second piece, it basically just tracks this language and adds it to the Constitution. But we just want to make sure everybody has the language for this first bullet here, and that's how the Constitution would be amended.
So
Go ahead, Mary.
real briefly on Prop 6, I do think that it is noteworthy that a number of states have already done this, and without any parade of horribles flowing from this, this measure would change our Constitution to make clear that we are not going to allow forced labor in prison. That's really the only place where forced labor is currently allowed, and that tracks the the 13th Amendment to the Constitution, which abolished slavery under the US Constitution, but said that with a carve out for people who were incarcerated. And a number of state constitutions had tracked that same language. A number of them have now made the change. The only one that has had any issues or where it did not pass was Louisiana. But I think it needs to also be said that this would not, and the language is clear, that it would not prevent work in prison from being used to go to credit for a positive thing. So in other words, it can be a carrot to do work while in prison. And I think the other issue that has come up with this that people are concerned about is, well, would this provide some sort of right to people who are incarcerated such that they would have to be paid a minimum wage? And there's nothing in this measure that says that the state minimum wage laws would be applicable to people who are incarcerated. And again, I think those are kind of questions for another day. If this passes, there might be a movement to try to ensure some sort of minimum wage for work while incarcerated, but that's a next step, and that's not addressed by this measure.
The politics of this measure are incredibly interesting. This is sort of a classic, I think, tension point between people who want to expand civil rights and social justice and a little bit of criminal justice, and sort of, I think, a different point of view that a chunk of voters in the middle have, which is they are all on board for increasing social justice and criminal justice and even increasing constitutional rights. Note this public opinion on Prop 3. On this one, and I've been in some focus groups on this, and I'll just say that the PPIC has it at 4650. Where voters are is voters see this as letting people off the hook. They think that why are we expanding the rights of people who are in prison, as opposed to focusing on themselves? And this is sort of a broader, and this is like not commenting on this and not fair or unfair, right? This is part of a broader dynamic that's going on in society in the United States, but in the electorate for sure, and particularly here in California, where people see there's a common sense that's pervasive, that people get the sense that other people are getting advantages that they're not, and other people are gaining benefits that they're not. And that applies to corporations who get away with things that they don't think that they should be able to get away with. Well, why don't I pay lower taxes? It applies to even like homeless people. Like, why are they getting benefits? Why are they getting support when I'm struggling to pay for higher food prices and I can't get ahead, and I don't know how I'm going to pay for my kids' education or their college? It even extends to an issue like this in the social justice space or the criminal justice space, where they're like, why are we caring and changing the Constitution to advantage or benefit this cohort of people who are in prison because they've done something wrong? And why isn't someone coming along? And so people sometimes respond to these issues on a very visceral level without sort of engaging in an internal rational debate of any kind. And when they see something like that, it creates some internal tension. And this one's going to be very interesting to watch. There's not going to be much money on either side. There's a small campaign to pass it. I don't think you're going to see much campaign on the opposition side whatsoever. This is going to be one of those things that voters figure out themselves. That's a little complex, but I wouldn't be surprised if that resistance, that what about me, doesn't end up prevailing. This goes down.
Okay, real quick, housekeeping. Well, my MCLA codes, yeah, you'll get a certificate when the program ends. The other question is, Mary Beth, if you maybe want to address this. I think this is discussed in a little more detail in the voter guide, but what involuntary servitude is happening in prison in California now? I think that surrounds the definition of what involuntary servitude is. But there's a question on what's happening now that would be called involuntary.
Yeah, so I think it's so interesting because, Ned, your comments were really so interesting to me. I think you're right. I also think it's not a complicated measure. Like, I don't actually think that there is all that much involuntary servitude going on currently in the California prison system. There may very well be, some incarcerated people who are assigned to work that they have not chosen or they wouldn't choose. But I think that the incentive programs that are set up for encouraging work that actually are linked to rehabilitative aims, like people having jobs, is a positive thing for the most part when they are incarcerated. And so because of the credit to reduce their sentences that's offered, that's not involuntary servitude. If they're choosing to do it to have a reduction in their sentence, that would not be classified as work that they are not, under this change, they would still be allowed to do that in exchange for credit. So I actually think that it's not, as a practical matter, going to make a very significant change to the lives of most inmates. But I do think that having the California Constitution very clearly state that slavery and involuntary servitude are prohibited in our state is a messaging thing that some people are very keen to have done. And I will also say that this measure was part of the Black Legislative Caucus agenda to as part of a larger package to acknowledge the problems of our state had with slavery and with racism throughout its history. And so this is part of a larger reparations package, even though it doesn't actually provide any direct money or support for people who have a history or ancestry relating connected to slavery. Sorry.
Okay, I'll do one more real quick. I think it's a yes or no on Prop 6, and then again, if we get time at the end, we'll circle back. But just to keep moving through, do you see Prop 6 providing additional cause of action for incarcerated people to sue CDCR to improve working conditions?
I don't think that this measure in and of itself does that. Those would be, again, I think, separate concerns that might be brought up later. But I don't know that this provides a blueprint for that.
Okay. So now we move on signature qualified measures. These are initiatives. Signatures were gathered. They were put on the ballot by the people of the state of California. First one is Prop 32. Mary Beth.
Yeah, so let me just say, I think there are a couple important things to point out with respect to this one. This is a statute that would increase the statewide minimum wage, and the ways in which it would do that are listed here on the slide, which I'm not going to read. Two important things to point out. Originally, this one was supposed to qualify for the November 2022 ballot. The signatures were in time, but the certification did not happen in time. Some of the counties did not verify the signatures in time for November 2022, so it was pushed to 2024. I think if it had gone forward in November of 22, it would have been a fairly significant boost in the minimum wage at that time, and I think it would have been more meaningful. Now that it's 2 years later and that we've already had a lot of legislative action on the minimum wage, including laws that have made the wage increase every year, every January, we've seen increases for inflation. And so now the statewide minimum wage is already up to 16, it'll be at $16.50, I think, by January 1. So you're really talking about just about a 50-cent increase from this. We also have a number of local jurisdictions that have passed even higher minimum wages than the state. And so in many jurisdictions, the minimum wage is already up over the 17, and in some instances already up over the $18 an hour mark that this measure projects for 2026. Plus the fact this, if it passes, will pause those increases until we get to the $18 an hour, the inflation increases. And so as a practical matter, for many people, depending on where they live or depending on what industry they work in, they may already be getting more than this minimum. But this would set a statewide floor. And the other thing that I think is important to mention that is not talked about is that the minimum wage law is also currently used to set the minimum salary for exempt employees. And so as a practical matter, this increase will be pretty meaningful for exempt salaried workers. Right now, in order to be exempt, the salary is about $64,000 a year is what the lowest level exempt employee needs to make. And this boost would actually bring it up to about 74 or 75,000 a year. So it's that's going to be a significant change for some employers who may have exempt employees who are at the minimum threshold for exemption.
So the politics on this are this is an interesting issue because everybody knows what minimum wage is, which means that the starting point for public opinion means that people have a pretty good, already have a pretty good sense of things, right? Like there's way less opportunity to move people back and forth than to persuade people to change their mind because they already kind of feel like they know what it is. The PPIC, I think, had this at 50-49. Most recently, I've seen other private polling, which had this at sort of 54. I think oddly, I don't think there's going to be much of a campaign on either the yes side or the no side here. I think the business community looks at this as vulnerable, but I don't think that they're going to spend the money to actually go after it. I think labor feels like they're caught in a bind because they didn't put this on the ballot. Joe Sandberg did, who's a kind of a VC guy, venture cap guy who has talked about running for office, who's done things on living wage. Missed the
But
ballot.
He's not campaigning on it. He's dumped it.
Yep, he's closed his committee. He's not going to be spending any money on it. So, and like labor sort of feels like they got stuck with it. They're not thrilled with this. So I think it's going to be very interesting to see what happens here. In that, again, you have existing opinions and attitudes about a minimum wage, which are fairly entrenched because people have a pretty good sense what it is. At the same time, you've got that macro opinion environment that we've talked about, where people feel really sensitive to rising food costs, right? And like you're hard pressed not to go out and talk to somebody in Middle California, right? Who hasn't paid $20 for a burrito at Chipotle recently. And that's like a little bit of hyperbole, but like not that much. Like you talk to parents, you talk to people, like they feel like So there's a connection that people have that the more the minimum wage goes up, they believe that that means that they're going to be paying higher freight on things. So even if there is an ideological disposition for California voters to start off at like, 54.45 or something on minimum wage, this issue environment, this attitudinal impact that we're going through right now, given coming out of COVID with all the rising costs, could actually erode that even in the absence of a campaign. It's likely that this is going to pass, but it's not a slam dunk by any measure.
Okay, will passage of Prop 32 make it harder for labor to get a higher minimum wage in a couple of years because people will say we just raised it?
I think it makes it easier. I think honestly, I think that's a great question. And this is one of the things that perplexes me about the business community not engaging on this. By raising the minimum wage now, you essentially shorten the delta between where we are and where labor wants to get, which is closer to 25 or 26. And so by doing this incrementally, you're actually sort of getting a little bit closer to it, which makes it harder to sort of go to voters and say, oh my God, they're talking about raising the minimum wage 35%, which is going to scare some voters.
I also just mentioned that the pause button in this measure, as soon as we get to 18, will go away and the inflation adjustments will start happening again. And so I actually think it's not going to be harder.
Okay, thanks. And we will be getting to fast food minimum wage later on, which is not on the ballot, but fast food minimum wage is its own thing, and that's coming up. Stay tuned for that. So that's 32, 33 and 34. I'm just going to flash both of these and then we'll come back to 33. For y'all who've been watching TV, you might have seen ads that they're running together. There's the yes, no, and there's the no, yes. And you may be wondering what's the connection between rent control and 34. So we're about to explain what's happening here on 33 and 34. It's very interesting, worth the price of admission by itself. So we'll start with 33, but then we'll do 34 and we'll wrap them both together. Okay? So we'll start with what 33 does on its face.
Okay, so Proposition 33 will repeal the Costa-Hawkins Rental Housing Act of 1995. There have been a couple of attempts to repeal the Costa-Hawkins Rental Housing Act that have not been successful. So this is the third try, maybe third time's a charm, we'll see. But basically, Costa-Hawkins has limited local government's ability to pass rent control laws, and the repeal of this act would allow for cities and counties to maintain their existing rent control laws that they had that are narrow in scope because of Costa-Hawkins, or to enact or expand more rent control ordinances in their localities. So it's actually going back to the straight up repeal that was tried the first time that a voter initiative was brought on this topic. In the second effort, that was more of a reform to Costa-Hawkins. This one is back to being a straight repeal. So one of the things that you're hearing a little bit about on this one is this concern that this will wipe out about 100 existing state laws around that have been put in place to try to support or modify the Costa-Hawkins Act. And it's true that as a practical matter, we would be putting the control back in the localities for rent control and removing the ability of the state to prevent local governments from having those ordinances. But that's basically what it does. We're basically shifting who gets to be in charge of passing rent control ordinances if we pass this measure. The way in which Prop 34 relates to this is, as a substantive matter, really not at all. They're very different measures. Prop 34 is a very lengthy and complicated initiative that purports to be directed to the ways in which revenues from federal prescription drug programs can be used. And it purports to say that companies that are involved with getting revenues from federal discount prescription drug programs have to spend 98% of those revenues on patient care. Okay, really what Prop 34 is an attempt to reduce the amount of money that the AIDS Healthcare Foundation and Michael Weinstein have to spend on passing rent control initiatives. So Prop 33 is the proponents are, and a large funder of Prop 33 and of the efforts to repeal the Costa-Hawkins Act are, so a huge proponent is Michael Weinstein and the AIDS Healthcare Foundation. They're the yes on 33. They're also no on 34, which 34 seems to be directed specifically at limiting the amount of money that one organization has to spend on issue advocacy and on initiatives. And so that's why these two things are connected. There's a note here at the bottom of this slide that says that the AIDS Healthcare Foundation has already tried in the courts to challenge this initiative to get it removed from the ballot as a piece of legislation that singles out one entity, also called a bill of attainder. And the court allowed the initiative to go forward, said it would not remove it from the ballot, but it left open the possibility of the challenge being renewed if it passes. And I think there's no question that this will go to litigation if Prop 34 passes. Just real quickly, generally speaking, courts will only entertain pre-election review, will only entertain the possibility of removing a ballot proposition from the ballot if the people do not have the power to pass it, if it goes to the fundamentals of whether or not the initiative is lawful to be voted upon. For things that are constitutional challenges, the courts in California will generally not take those up pre-election. They'll say, we will not entertain this litigation until we know if it passes. So the court here did not say, we think it's constitutional. They just said, we think that the people have the power to vote on it. We'll decide whether it's constitutional later if it passes. So that's just a basic breakdown of the types of standards you need to meet in order to have a pre-election review rather than a post-election review.
Okay, and then there are a couple questions here. I think let me just do the one that I think is pretty straightforward. Will Prop 33 take away the guarantee to vacancy decontrol?
Take away the guarantee to vacancy decontrol, right? I'm not sure I understand that question. Do you understand that, Ned?
Nope.
I think I understand vaguely, so I'll give a vague answer. But by itself, it wouldn't per se do it, but it would allow the locals to do things they can't do now. Hopefully that's responsive. If this is the increase the rent after somebody moves out and you have a new tenant, but I could be wrong. But here's sort of the political thing. So if you look at the ads on TV, they run by pretty quickly, but you can see at the bottom who the funders are. So Ned or Mary Beth, if you want to take this one, it's sort of like, where's the money coming from on those who support 33 and oppose, I'm sorry, those who support 34 and oppose 33 and vice versa. Can you talk a little?
So it's the California Realtors who are, and the California Apartments Association, sorry, I think it's the Apartments Association that is promoting Prop 34 and is opposed to Prop 33. And the AIDS Healthcare Foundation is supporting 33 and opposed to 34. And those aren't the only ones, but those are, I would say, the driving forces. There are other groups and organizations that are lining up on both sides.
So this is again, not commenting on the right or wrong of it, any of this stuff. This is the interrelationship between 33 and 34, why a lot of California voters in focus groups and opinion research will throw up their hands and say that the initiative process is lousy and needs fixing because it's so complicated. This is really just apartment owners don't like rent control, so they're opposing 33, and they don't like the guy, Michael Weinstein, that keeps bringing rent control measures. So this is their way to dry up his Prop 34 is the apartment owners' way of drying up Michael Weinstein's funding so he doesn't get to push any more rent control measures. It's like there's a little bit more complex than that, but not really. The money on this is going to be on both 33 and 34 because you need to think about them as a pair, right? No on 33 is yes on 34, and yes on 33 is no on 34. Almost like that's how the coalition breaks down. Is the apartment owners are going to spend in past rent control measures to defeat them, they've spent upwards of $90 million each time. Michael Weinstein has spent somewhere in the neighborhood of $20 or $25 million out of the AIDS Healthcare Foundation, both time in support of both measures. Both rent control measures in the past, the last two to be on the statewide ballot, lost by 20. They lost 60-40 and lost 59-30-41 or something like that. So the apartment owners can beat rent control. They're just sick of having to go out and spend $90 million or $100 million every couple of years because they don't want to have to go out and do that and beat rent control. That's what Prop 34 is essentially their effort to sort of neutralize and put their antagonist on the sideline. The money on this is interesting. Michael Weinstein and the AIDS Healthcare Foundation are spending more on rent control this year than they have in the past. So I think that they think they have a better shot. Prop 34 is diluting that spending. As you can tell from this discussion, running a no yes on one thing and a no on another at the same time is complicating. It dilutes your message. It means that people don't know what you're talking about, and you're talking about two things. So the polling on Prop 33, there's widespread support in California for rent control, but the polling on 33 is closer. And I think PPIC had it at 51-46. If the pass is any guide, the Apartment Association is going to be able to defeat it. They're going to spend another $70 million. They're going to spend another $100 million, whatever. They're going to defeat it. It would be surprising somewhat if they don't. Prop 34 is more jump ball. Nobody knows what's going on with it, right? It's not like it's meeting some, oh my gosh, like voters wake up thinking about this every day, right? So there's a possibility that it passes, although will be interesting. And then almost certainly is going to be litigated. And, Mary Beth can comment on sort of the potential success of that litigation, but going after one entity with a ballot measure is almost certainly a constitutional no-no.
Yeah, it's a constitutional no-no. And I mean, just if you even just look here at the bullets, right? Never mind actually reading, but if you follow the very narrow scope of who this measure applies to, it has to be somebody, it has to be an organization that spent a certain amount in a 10-year period. It has to be one that also operates multifamily housing units that have at least 500 high severity health and safety violations. It has to be somebody who's involved in very specific programs. It is very narrow. It is, without saying this applies to only the AIDS Healthcare Foundation, without actually writing that, it does that. So I think, now there's a question in the chat that said, can you vote on both? And the answer is yes, you can vote yes on both of them. You don't have to vote yes on one and no on the other, but but their funding is all very connected.
Yeah, and then there's another question, can I vote no on both? Yeah, they're not mutually inconsistent. We've seen that before where you could not have both. In this case, you could have both and you could have neither. So they're politically joined, but not legally joined. I'm going to try and pick up a couple more here. There's some questions here. Okay. Prop 33 would make it so local government could make it so single family homes are under rent control. Correct. Because that's everything that Costa-Hawkins, as a matter of statewide law, prohibits would be repealed. So
Correct.
the single-family homes limitation on rent control is statewide statute. So just as one, that's a clean and good example. If Costa-Hawkins repealed, then the locals could do rent control on single-family homes. I think there were a couple other things in here. One, I could paraphrase, or I could try and find it, but maybe Ned or Mary Beth, you could address this. One of the arguments on the rent control is about the pool of affordable housing that would be built or maintained if rent control passes. That's one of the political arguments being made. Can one of you talk a little bit about that? The link between affordable housing, new housing, and or maintenance of affordable housing and the rent control issue?
I'll defer to Ned on the political side of this, but I'm not really sure that they're two different things, right? The rent control is not going to, I don't think, drive a lack of new housing to be built. I suppose that if it's not profitable for developers to build new units, that they won't. I guess I'm just not myself, I'm not understanding how it would be any different if the state is in control of passing some of these laws. The Costa-Hawkins law itself specifies that there are certain types of housing that can be subject to rent control and certain types that can't. I don't know. Ned, do you want to take that one?
Yeah, so I don't, we just outkicked my coverage or like outkicked my knowledge, but there are a couple of notable affordable housing advocates in the legislature, like Tony Atkins and Buffy Wicks, who both Democrats and both progressives by all intents, for all intents and purposes, who are opposing Prop 33 because of this argument about its impact on existing affordable housing laws. And so I will only say, not that I understand the argument, but I only will say that if you are judging by the people who are responding to it, and if you place any credence in what Tony Atkins or Buffy Wicks think, that's one signal that it may. I would just flag also that, like, again, I don't have a position on this, professional or personal, but like Michael Weinstein, who is the author of this measure, is seen in the housing community as a bit of a lone wolf and hasn't always like worked with people on the drafting of the measure and of the language and of the early work that's done, which is a critical phase and a critical thing for making sure that you avoid unintended consequences. So it certainly is possible that he kind of stumbled across something by mistake and then just was unable to fix it.
Okay. A couple more on the details of 33. I'm not sure we've fully explained, but the actual ramifications of 33 by itself, repealing Costa-Hawkins, and the ability of locals now to do things that are prohibited under Costa-Hawkins and would not be, and whether there's one comment in here that single-family homes are under rent control in some cities, but
depending on when the single-family
Right.
homes were built. I mean, Costa-Hawkins has all sorts of very highly technical provisions about what is covered, what isn't. And so what I guess I would say is, I don't think that we would be the wrong people. Like, I would be the wrong person. I think Ned would be the wrong person to talk about the substance of rent control. There is some argument to be made that this is why these things should not be done by ballot initiative, because it's highly complicated. And what I would say is, I don't know that anyone can tell you with certainty what the consequences would be of Prop 33 passing, because we don't know what the local governments would do if given the ability to have this state law repealed. So I think it's a kind of wide open question about what we might find once that had happened. Right now, we have a lot of restrictions. We have certain rules for housing that's built before 1995 and certain rules for housing that's built after, and certain rules about multi-unit dwellings and certain rules about single-family homes. And I think that the whole of the Costa-Hawkins Act that has all of those technical rules in it, and some additional laws that have been passed to supplement it, Costa-Hawkins would be repealed. Whether or not some of the other state laws surrounding it might survive, these are questions. I don't have the answers.
Yeah, and we have a few more coming up. So there are a number of slides in here that cover issues that could be their own hour-and-a-half program. Okay, we're going to get to PAGA and a couple other issues down the road. So we're doing what we can here, but we're not between the three of us. We just don't have the deep subject matter expertise on substantive rent control law to answer all these questions. And we're not trying to avoid anybody. It's just,
Oh, I'm trying to avoid them.
well, Mary Beth is trying to avoid. I'm trying to admit that we are trying to avoid. So again, these are all really solid questions, but maybe someone else can dive deeper into that in a standalone program, because it could be an hour and a half. That's 33. That's 34 we've covered. Now, let's see. Oh, this one, 35. Are we back to Ned? 35, we're back to Ned.
Prop 35 deals with something called the MCO tax, which stands for Managed Care Organization Tax, which is a mechanism essentially that California and other states use to draw down federal funding. If you tax manage healthcare organizations like health plans, essentially, it enables you to use that money and bring in more federal money to draw down more federal dollars, right? So it's perceived widely to be something where, yes, you're taxing plans, but actually it's increasing in California, but you're actually increasing the amount of revenue that the state of California gets overall. California traditionally has used the MCO tax as a frequently in many years to sort of steer that money towards healthcare, which is what federal law around the MCO tax requires. However, everybody on this phone calls or on this Zoom is familiar with the fact that California's had a number of bad budget cycles, and in last 20 years. And when California goes into a bad budget cycle, the state has frequently used the revenue from the MCO tax to pay for things other than healthcare. So to pay to avoid cuts to schools, to avoid cuts to parks and to other state funded programs. Prop 35 is put on the ballot by a coalition of healthcare providers, largely the Hospital Association, the Medical Association, Planned Parenthood is involved, some clinics are involved, which is as essentially it said, enough is enough. We are going to, we're going to make this tax permanent rather than have the legislature pass it every few years. B, we are going to direct that money only to healthcare so that the state is no longer able to raid in their view this money to spend on other things in poor times. And because they are essentially preventing the state from spending this money on other things, they are now requiring the state to, it will be a hit on the general fund of something like $1 to $2 billion a year. The backers of this measure have something like they've got a budget of something like $40 or $45 million, right? They spent $10 million to put this thing on the ballot. It is supported by not just those backers, but it's supported by the California Democratic Party and it's supported by the California Republican Party. There is zero funded opposition to this. The one place that there might be some opposition, or a couple places there might be some opposition, the governor doesn't like it. He's implied thus in public comments. He hasn't opposed it. He's not opposing it, but he's implied that he doesn't like it. Other revenue constituencies, folks like CTA and other folks that benefit from that revenue, right, would like that access to that revenue in tough budget times. They also don't like it, but they're not opposed, and they're unlikely to put up any kind of opposition campaign. This is polling something like the recent PPIC, something like 63-35 or something like that. So this is essentially something that the vast majority of California voters don't care about. It's not going to impact their regular lives, right? This is a classic example of an interest group essentially using the initiative process to leverage for their own benefit and to leverage for their own gain. The argument in favor that's a little bit more selfless or a little bit, a little less self-serving is that this is going to help expand. It's going to help support and bolster the Medi-Cal program, which historically has underpaid doctors and hospitals. And because it has underpaid doctors and hospitals and other healthcare providers, has led to real gaps in the safety net here in California in terms of people's ability on Medi-Cal, their ability to access the healthcare that they need. So the two sort of flip sides of this, even though there's not going to be a campaign, are on the one hand, this is a money grab by the healthcare industry, right, to give themselves a raise. And on the other hand, it's like we're going to steer more dollars towards healthcare for our most vulnerable to make sure that they've got better access to care. Ultimately, all of that's going to be a wash, and this thing's going to pass by 20 or more in a walk.
Okay, does 35 have an exception for emergency budget years?
I think they built in they've got something which exists for the first 2 years, I think, and then it turns on permanently in 2027, I believe.
Okay. No more questions on that one. Okay, we're going to get to Prop 36 in a second. We're not going to do this 11 bill package, but it is relevant to 36 and the substance and politics around that. And again, when you get your written materials, all these links are live. You can click on them. You can read the bills as enacted. But this is the legislature's property crime and retail theft package. Ned will explain why this is what it is and all the politics and issues surrounding what is the only proposition on the ballot, which is dealing with this issue, which is Prop 36. So I think Ned and Mary, I think Ned's the lead on this, but Mary Beth has
I'm gonna kick it off and then let Mary Beth handle some of the details, hopefully. So Prop 47 Californians passed back in 2014, changed some theft and drug crimes from felonies to misdemeanors. Basically, right? It was part of a criminal justice reform to keep people out of prison. And so they did that by changing the level of sort of the threshold for what qualifies as a misdemeanor versus a felony. DAs didn't like, a lot of DAs didn't, not all the DAs, a lot of DAs didn't like Prop 47. There was a perceived uptick in related crimes that has happened over the course of the last 8 years or so. There's debate about whether that uptick was real, whether it was perceived, or whether it was contrived by people who never liked Prop 47 in the first place. But there has been an increased, put that reality aside, right, that policy debate aside, there has been a increased perception amongst the electorate, right, and perception's reality sometimes. There's been an increased concern about safety and about concern about rising crime, and that has been fed by local news coverage of things like smash and grabs at Walgreens and smash and grabs at Target, and smash and grabs at Rite Aid. And like, if you talk to voters on this, because we've done that, if you talk to voters, I'm not working on this campaign, but we've done research on it. If you talk to voters on this, they note things like, when I go to Target now, I have to go get help in order to get some things out from behind locked glass. There's, again, putting aside the right and wrong of this, there is an increased sense of unease amongst some part of the California electorate about public safety and their own safety and community safety generally. So that plus Prop 47 are sort of the environment in which Prop 36 is happening. Prop 36 was put on the ballot by a coalition of DAs and some big box retailers, primarily Walmart and Target and a couple other folks. To address some of their concerns. It does a few things. It increases punishment for some threat, theft, and drug crimes, which is sort of a direct response to Prop 47. And these changes undo some of the punishment reductions in Prop 47. It lengthens some felony sentences. It requires some felonies to be served in prison. It does create a new court process for some drug possession crimes. and allows people who possess legal drugs to be charged with a treatment mandated felony instead of a misdemeanor. And finally, it requires warning of possible murder charges for selling or providing drugs. It is a much more complicated measure than I just stated. It's something like 40 pages long. The politics of this are interesting. The politics of this are, you've got this, 70%, I think the polling on this in the recent PPIC was 71 yes, 26 no. So if you ask people, if you ask the electorate about this, right, there's this rising concern about crime, rising concern about community safety. This fits very neatly within where the electorate is. At the same time, though, it cuts against some of California's recent moves towards criminal justice reform and prison reform, and to try to change our approach to crime and change our approach to rehabilitation and incarceration. It has those two conflicting currents, and so the governor did not like Prop 36 when it was initially filed, and there was nor did a bunch of social justice groups or criminal justice groups. There was an effort in the legislature to essentially try to do two things, one of which was to pass laws which address the retailers and DA's concerns to obviate their need for a ballot measure. The other track was related, there was discussion of putting on a competing measure, the legislature putting on a competing measure that did some of what Prop 36 would do, but not all. That was supported by the governor and some folks in the legislature. That effort collapsed, and we can talk about why it collapsed, but that effort collapsed. The legislature moved forward with the 11 pieces of legislation that's all had up on a previous slide. None of that was enough to essentially get the DAs at least to back down and to pull Prop 36. I think the retailers would have cut a deal, but the DAs weren't interested in doing so. So you essentially have Prop 36 now going forward, and this legislation going forward, and Mary Beth can sort of talk about the tangled mess that may create if Prop 36 is going to pass. This measure is in all likelihood going to pass. There's very little money on the no side. There's a lot of intensity amongst some groups, but there's very little money. A lot of the folks that normally fund social justice and criminal justice reform are really all in on the presidential race, which means that there's less to take on measures like this. The yes side spent $10 million or $8 or $9 million or whatever, and maybe has another 5 or 6 they're sitting on. That's not big by ballot measure standards. They're probably not going to raise much more if they don't have to. So despite the fact that this has gotten so much heat and light and sort of public attention and so much scrutiny, and that it's been sort of like maybe even the biggest issue in Sacramento, or one of the top two or three issues in Sacramento, it's not going to be one of those big spending campaigns where voters are just getting bombarded by information from both sides. Ultimately, I think some will say that this is a bit of a crude tool and probably goes too far in trying to address what some people might believe to be some of the shortcomings of Prop 47, or even non-Prop 47 related need to act and to improve public safety. But that's not going to matter. It's very likely that this thing passes and that we're going to have to deal with the aftermath come December. Yeah,
and then there's one in here. I think maybe Mary Beth can give some context on what we've gotten ourselves into on initiatives. So the question is, why wouldn't this be just pieces of legislation as opposed to one big omnibus ballot measure?
Yeah.
Because they would fail in the legislature, and if you could talk about that legally.
Well, except some of the provisions wouldn't fail in the legislature, as was demonstrated by your first slide here, Saul, about all of the various legislative packages that did go through and that were able to successfully go through. I do think that there will be a question if some of those legislative provisions that passed and have been signed and are due to take effect on January 1st, if they were amending the same provisions as some of the provisions that are going to potentially be passed in Prop 36, which is quite likely, then we have a potential conflict between two different pieces of legislation, one passed by the people, one passed by the legislature. This has happened before, and for the legislative analyst's office to be able to figure out which provisions will take effect. So we'll have legislation that was passed prior which normally if the initiative is a later enactment, that language might take priority. But it also may be that some of these provisions can be harmonized. And so we really will have a bit of a mishmash at come January, when we're trying to figure out what laws will govern and what sections, some of the sections changed by the initiative might change provisions that are no longer going to be the language based on the legislative changes. So it does create problems when we have the legislature and the people trying to make changes to the same statutory sections at essentially the same time. So that's a challenge. I also noted that somebody in the chat asked about the Supreme Court decision that found that California was violating the Eighth Amendment by overcrowding. And so Prop 47 was, part of a solution to limiting, Ned's
I'm
got
sorry,
out.
I've got a family thing I've got to jump. Thanks. Sorry, Saul. Thanks.
All right, it's okay.
Bye, Ned. So the answer is yes, California was involved in litigation and challenges that resulted from the need for California to reduce its prison population, and that has been successfully done over the past many years through a combination of policies that were passed through the legislative process. Also, Prop 47 definitely helped with that by diverting more people to county jails instead of state prison. That was through realignment. And there is some concern that as a practical matter, that increasing penalties and increasing state prison terms again for things like theft and possession offenses, drug possession offenses, that we will quickly get back up to numbers of incarcerated people that will once again put California in the crosshairs of violating the Eighth Amendment because we have overcrowded prisons. So I do think that that's, it is a potential issue that may reemerge. I guess the other thing I would say, my students who are working on this one in particular have looked into some studies that have been done at UC Irvine and at other institutions in California that have really looked at what the consequences of Prop 47 were. And the studies do not play out the narrative that Prop 47 has resulted in an increase to these types of crimes. And so, not that I think if Ned were here, he would say, it doesn't matter what the studies say. It doesn't matter what what a scholarly look at this would tell us. It's how people feel. And voters are going to vote based on how they feel. And that is a truism, right? That's part of the both beauty and challenge of the initiative process. And it's also a challenge that we have the ability under our California Constitution to do such comprehensive changes through an initiative process, where it's very difficult to vote up or down on any small piece of this measure, because it does do many things, and you have to vote yes or no on all of it.
Okay, thanks. So couple things. Copies of written materials. Everyone who registered will get an email with your MCLE certificate and either access to or the actual PDF. So that's Prop 36. So that brings us to the end of what will be on the ballot. So that was the main event. We got about 5 minutes left, and we're going to just quickly go over a few things, 3, maybe more, that were qualified to be on the ballot but are not on the ballot. We're going to hit real quick 3 different versions of that: removal by the Supreme Court, 1 initiative, and 1 referendum. But let's see what we can do in 5 minutes, because again, You have the information you need now to make your decisions. So here is the first one. Mary Beth, you want to talk a little bit about this?
Yeah, I'm going to just talk really quickly, first of all, about the fact that we had an unprecedented number of initiatives that qualified and then were removed from the ballot. So this is kind of a new territory. There were 9 qualified ballot measures. We could have had 19 things to vote on. Instead, we only have 10. So be thankful, I guess. The Taxpayer Protection and Government Accountability Act was the only one that was removed by the court. So the other 8 qualified ballot initiatives were removed through some sort of legislative compromise that had the proponents actually voluntarily pull their initiatives in right before the deadline. But the Taxpayer Protection and Government Accountability Act was removed by the California Supreme Court. And it was an initiative that would have made several changes to tax, the way we do taxes. It would have required voters to approve any tax increase, and it broadly defined tax in ways that were much larger than have previously been defined in California law. So it also would have required voters to approve local taxes by a 2/3 vote instead of a simple majority. And it would have changed the way in which the state needed to be involved in imposing fees. So the legislature would have needed to give would have needed to pass very clear legislation allowing for the imposition of fees, and it would have pulled that role away from administrative agencies in a number of circumstances. The California Supreme Court said that the kinds of changes that this initiative was making went to the heart of or the core of governmental functions, and that so much so that what the proposal did was a revision of the Constitution because of the change in the balance of powers between the state and the localities and between the state and the administrative agencies. And so this was a revision, not an amendment. And under the California Constitution, revisions must be made either through a constitutional convention and then a vote of the people, or through a 2/3 vote of both the Assembly and the Senate, and then a vote of the people. This was presented as an initiative constitutional amendment, not through the revision process. And so the people did not have the power to amend the Constitution. They do not have the power to revise the Constitution in the way that this initiative was trying to do it. So it was rejected as a revision rather than an amendment.
Okay, we got about 2 minutes. We got 2 more.
Okay.
Well, we'll get through this. As I mentioned, we could spend an hour and a half on PAGA real quick, Mary Beth, without getting.
Yeah, I don't know that I can talk about PAGA real quick, but
Right.
I guess all I will say is that that the Private Attorney General Act was up for repeal. There was an initiative that qualified that would have repealed that. It was withdrawn by the proponents after there were legislative bills that were enacted that basically made enough amendments to it to make the proponents comfortable. I will leave it at that for that one.
Thanks. And that's sort of similar to this one. You want me to do this real quick?
Sure.
Unless you want to. Similar to this one, although this one has a long history because there's several years of legislation. This is one you might have seen in the newspapers: fast food, minimum wage, and other things. So in 2022, AB 257 was enacted, would have established a fast food council and done numerous things, including raise minimum wage in the defined category to $22 per hour. There was a referendum that qualified that would have repealed 257. AB 1228 was introduced in 2023. The referendum was, well, the enactment of AB 1228 was contingent upon the withdrawal of the referendum challenging 257. So 1228 was enacted. It's a version of 257 that has some different things, including the amount of the minimum wage, the definition of who would be covered. And this is sort of a hidden but a very important issue that you won't see on the face of 1228. In 257, it was originally included but removed prior to enactment. It would have imposed joint and several liability on franchisee and franchisor. And that's a huge deal in the franchise community. So that was not included in 257 as enacted. It was put into 1228. So as part of the negotiations, that piece was removed from 1228. So 1228 as enacted does not include the joint and several liability. The referendum was withdrawn, and 1228 is now the law. We have, we're 1 minute over, but we have one last slide, or depending how you count, because I got a couple of issues here. This is just the names of 4 other, let's see, 3 initiatives and 1 referendum that qualified and were withdrawn. We really didn't intend to spend time on the substance because we knew we'd run out of time, but those are what they are. And with that, I thank you all for being here. We opened this up to everybody, CLA member or not. If you are not a CLA member, hopefully you've enjoyed your experience, and hopefully we can encourage you to join CLA. All you have to do is go to this place here and join. If you have any follow-up questions, you'll be getting an email from the registration team. It's like registration at whatever. Mary Beth, I, and Ned are around to answer any follow-up questions. And with that, don't forget to vote. There you have it. Enjoy the rest of your day. Thank you, Mary Beth, and we'll thank Ned.